Good morning, this is your Kelso Report for Friday, July 27th, and I'm your host, Clark Kelso. We begin today with a couple of grants by the Ninth Circuit of in-bank review in a couple of interesting cases. First, the Ninth Circuit has granted in-bank review of its decision in February of this year in Haskell v. Harris, where the panel upheld California's law requiring law enforcement officers to collect DNA samples from all adults arrested for felonies. A two-judge majority upheld the law, concluding that the state's compelling interest in correctly identifying arrestees, solving past crimes, and exonerating innocent suspects far outweighed an arrestee's privacy concerns, given that the DNA is collected from a buccal swab of the arrestee's mouth, which the majority described as a de minimis intrusion, analogous to fingerprinting, that occurs only after a law enforcement officer determines there is probable cause to believe that the individual committed a felony. In dissent, Judge William Fletcher argued that the DNA samples are not really taken for purposes of identification. He's undoubtedly right about that. And that since in his view they are taken solely for an investigative purpose, the absence of a warrant or reasonable suspicion makes the process unconstitutional. I commented at the time of the decision that I thought it would be taken up in bank, if for no other reason than the majority opinion appeared to conflict with a prior Ninth Circuit decision in Friedman v. Butcher. Next, the Ninth Circuit's also granted in-bank review of its decision in April of this year in Stengel v. Medtronic, where another panel majority, over a dissent, affirmed the dismissal of several state causes of action, including a product liability claim, against Medtronic Incorporated for injuries sustained from the plaintiff's use of a pain pump manufactured by Medtronic. According to the majority, the medical device amendments of 1976 to the Food, Drug, and Cosmetic Act, as implemented by the Food and Drug Administration, established federal standards for medical devices, such as the pain pump, that could not be varied by state law because of an express preemption provision contained in the medical device amendments, and the substantial federal inspection, approval, and regulation of medical devices that occurs under the FDCA. This is an important enough issue that I think no matter what the Ninth Circuit does in bank, this one could well be headed to the Supreme Court for another decision about the interaction between federal regulation and state law. Next, we have a decision from the Ninth Circuit about court access to court records. The plaintiffs in In re Midland National Insurance Company filed 4 separate class action suits against 4 different insurance companies. In 2 of the cases, the plaintiffs filed oppositions to a motion for summary judgment and attached to their opposition a declaration by an expert on causation and class-wide damages. The defendants then filed motions based on Daubert to exclude the expert opinion. The trial court itself appointed an expert witness to assist the court in resolving the evidentiary dispute and ordered that its expert's report be sealed until the court determined whether the plaintiff's expert report was admissible. But before it could rule, these 2 defendants settled with the plaintiffs. At that point, the other defendants sought to unseal the court expert's report, which the district court refused to do. On appeal, the plaintiff tried to defend the unsealing by arguing that the report was related to a non-dispositive Daubert motion, and therefore the report did not fall within that class of court records that are presumptively open to the public. Well, the Ninth Circuit disagreed in a per curiam. It concluded that the sealed report was filed in connection with a dispositive motion for summary judgment, and was therefore presumptively open to the public. To seal such a document requires a showing of a compelling interest, and neither the plaintiffs nor the district court could identify any compelling reasons to keep the record sealed. The court remanded to give the parties an opportunity to redact any sensitive information, and then to have the records unsealed. We had another search and seizure case from the Ninth Circuit. The defendant in United States v. Valdez-Vega appealed the district court's denial of his motion to suppress cocaine found in his truck. He contended that the stop of his truck by Border Patrol agents 70 miles north of the U.S.-Mexico border violated the Fourth Amendment, and consequently the cocaine found in his truck must be suppressed. A split panel of the Ninth Circuit agreed that the search was unconstitutional, because the totality of the circumstances in the case did not provide Border Patrol agents with reasonable suspicion to believe that the defendant was smuggling drugs or aliens. In particular, the circumstances relied upon by the agents were nothing more than the following. They saw a driver of a truck with Mexican license plates committing traffic infractions involving speeding and frequent lane changes on an interstate highway 70 miles north of the U.S.-Mexico border. As the majority noted, those circumstances describe too broad a category of people to justify reasonable suspicion. Next, an Environmental Law Clean Air Act case. Two environmental groups had petitioned for review of a final rulemaking by the EPA that approved the siting of a power plant in California. Now, the groups in the EPA agree that the case needs to be remanded so the EPA may correct one procedural error and one substantive issue in the rulemaking record. So the issue in California Communities Against Toxics versus EPA was whether vacatur of the rule was also appropriate. The court here decided not to vacate the rule because the delay and trouble of vacatur would cause was severe. The rulemaking related to a power plant that was scheduled to come online in November to forestall possible blackouts next year, and the court was concerned that vacatur would pave the road to legal challenges to the construction that could well delay a much-needed power plant. The court noted that stopping construction would also be economically disastrous, since the construction project is a billion-dollar venture employing 350 workers. Now, the project remains at risk, of course, since the remand without vacatur does not authorize commencement of the plant's operation without a new and valid EPA rule in place. But it does appear the EPA will get such a rule in place promptly. Next, we go to the California Court of Appeal in a case involving the California Tort Claims Act. In Castaneda v. Department of Corrections and Rehabilitation, an inmate sued the state alleging medical malpractice in failing to follow up on a referral to a specialist to examine a possibly cancerous growth. However, Section 845.6 of the Government Code provides that the state may be liable to an inmate only, quote, if the employee knows or has reason to know that the prisoner is in need of immediate medical care, and he fails to take reasonable action to summon such medical care, close quote. The Second District held that this language makes it clear that there can be liability only for the failure to summon care, and that the state remains otherwise immune from liability if the care that is delivered is substandard. In other words, the state has waived liability only for the failure to, the state has waived sovereign immunity only for the failure to summon care to a prisoner. But it has not waived sovereign immunity for medical malpractice committed on a prisoner. That does appear to be the way the statutes are drafted. That's it for today's Kelso Report. Have a great day in the law and a good weekend.